Let's begin debriefing the February 2026 California bar exam, starting with Essay 1. If you have not watched any of our videos before, what we do here is read through the hypothetical and spot as many issues as we possibly can that are raised by the facts. To pass that essay, you don't have to discuss every one of the issues we spot, but the key issues have to be in your answer in order to achieve a passing score. We start with the calls of the question because we have to figure out what the subject is in order to have our organization of the law in mind when we start reading the hypothetical. This one has the three calls. First call, what claims and remedies, if any, may Reed reasonably pursue against Linda? That does not tell me the subject. It tells me it's probably contracts, torts, or property, because this is an individual making claims against another individual. Call 2, were the developer's residential deed restrictions valid? That's property. Call 3, will Nancy succeed in her claim against Linda? So far, I know that there's at least one call in property. The other two probably are property. We'll figure that out when we start reading the hypothetical. But first, let's take a look at what Dr. Sacuzzo thought might be on the February 2026 bar exam. He did really well on this one at figuring out what he thought would be there. You can watch that video on our channel. Here is, in essence, what he predicted. You see that property was not one of his main picks. It was one of his wild card subjects. Essay 2 on this bar turned out to be contracts. Essay 3 was PR. Essay 4 was civil procedure. And Essay 5 was community property. Notice that his third choice, evidence or con law, or a combination of the two, was not tested in the essays, but it was the subject of the performance test in February, the original writing rule, the document rule. So let's see what happens in July. Let's get back to the issue at hand, which is debriefing that first essay from the February 2026 exam, the property essay. We already know we have three calls. Let's start reading the hypothetical and see what it's about. It says Olivia owned a house in Havenwood, a subdivision with 15 homes on large wooded lots. The developer of Havenwood had conveyed each lot, including Olivia's, by a recorded deed stating that the conveyance was for, quote, residential purposes, end quote. That's the restriction that's the subject of call 2. Were the developer's residential deed restrictions valid? The restriction is that it's for residential purposes. So what do we know about that kind of restriction? Well, we know right off the bat that it's a covenant. It's a restrictive covenant. Those are valid as long as they are not illegal for an illegal purpose or an illegal restriction, such as a discriminatory covenant. And they have to be specific enough to be enforceable. They can't be vague or ambiguous. This one looks quite specific, and maintaining residential quality is not illegal. And knowing that it's a covenant, we know that one of these properties is going to be sold and that we're going to have to decide whether the burden runs to successors in interest. But the other thing we know is that these kind of facts, 15 homes, each conveyed by the same developer, each with the same restriction, sets us up perfectly to write about implied, reciprocal, negative easements. So let's take a look at the law we know for this kind of conveyancing. I'm going to the proponic schema, the way we organize law, and I'm going to look at real property. And there are the main topics tested in real property. Right now we're interested in covenants. Within that topic we see 3 subtopics: real covenants, equitable servitudes, and implied reciprocal negative easements. When you have a covenant in a deed, there are 2 ways to enforce that covenant. You can ask for a real covenant basis or an equitable servitude basis. They differ in the remedy sought. Real covenants are for a damages remedy. Equitable servitudes are for a court order. And then the special topic of implied reciprocal negative easements. There's a lot of detail nested within each of these, and I suspect that the main level of detail we're going to want is under implied reciprocal negative easements, because they really are setting that up in that first paragraph. So there are 4 elements. You have to have a common grantor, that was the developer. You have to have a common plan or scheme, that is to make the whole thing residential. You have to have other restricted lots, yeah, all 15 were, and you have to have notice. Actual, constructive, and inquiry, any one provides notice. And there are always defenses raised when you have an equitable servitudes hypothetical. You can fight the enforcement of the covenant by arguing changed neighborhood conditions, by arguing unclean hands, by arguing laches, and by arguing estoppel. So let's go back to the hypothetical and see what we have. The next paragraph says, when Olivia died last year, she bequeathed a life estate in her house to Linda, leaving the remainder to Reed. And now we have a new area, life estate. Back to the schema to look at present estates. Okay, here we go. Estates in land. We have concurrent estates, and that's not what we want. We have present estates. That's where you're going to find life estate. Let's go straight to life estate and see what detail we have here. We have the characteristics and we have the issues it raises. And I suspect this is going to be mostly about the issues a life estate raises. And there you see, pay certain expenses, not commit waste, and transfer only his or her interest. Okay, back to the hypothetical. But you see how little the body of law is that we need to memorize when it comes down to it right before the exam. And of course, you have to understand it thoroughly. That's just a summary of what you have to deeply understand. So, okay, Linda already owned a house and wanted to use Olivia's previous house as a florist shop instead. But that would violate the covenant, wouldn't it? Shortly after taking title, Linda cut down valuable mature trees. And right now on the bar, I would be writing in the margin, waste. And privacy hedges on the lot to make room for parking. She's committed waste. Linda then obtained a construction permit to renovate the house and a license to operate her business. Linda's renovation reduced the square footage of the house from approximately 5,000 square feet to 2,000 square feet, which significantly reduced the value of the structure. There is a lot in this paragraph that we need to talk about. These facts go to Call 1. Claims and remedies, if any, may Reed reasonably pursue against Linda. Reed is the remainderman. And Linda owns only a life estate. A life estate holder has to maintain and use the estate normally. Linda has not done that. She has cut down trees and hedges She has reduced the size of the main dwelling on the property and greatly decreased the value of the structure. So Reed can go after her for waste, and you can use all of those facts to show that he's likely to prevail, and he's likely to be able to collect damages for all of the changes she has made to the essential character of the property. You would also want to tell the grader that committing waste does not terminate the life estate. It goes on. The remedy is damages or injunction. So you'd also want to analyze whether Reed could get some sort of an injunction against Linda. It's difficult for me to see right now what that would be that the court would be willing to enforce, because they don't want to enforce something that means that they're essentially going to have to be a construction boss. But play around with that. See if you can figure out an injunction Reed could reasonably ask for as well. She has also violated a covenant, and that goes to call 3, Nancy making claims against Linda for violating that covenant in the deed. So what does paragraph 3 tell us? It says Nancy, one of Linda's neighbors in the subdivision, threatened to sue Linda for violating the residential covenant in Olivia's original deed. However, Linda pointed out to Nancy that 5 other businesses have been operating out of 5 homes in the subdivision for over 10 years, including 2 coffee shops, 2 clothing stores, and a dry cleaner. And neither Nancy nor other lot owners had complained previously. All of those facts go to the issue of whether this covenant can be enforced against Linda. So look, back up and think about this. Linda never signed anything, never bought a piece of property with this kind of a restriction on it. So it's not that she made a promise to the developer that this would be kept residential. So can we enforce that kind of a restriction against her when she wasn't the original promisor? That's why we need real covenant or equitable servitude as a remedy, because Linda is a successor in interest. If she were the original grant holder, it would be simple. She would be the one who made the promise. You can enforce it against her. But because she's not the original holder, we have to use real covenant or equitable servitude theory to prove that this can be enforced against her. In other words, that the burden runs to her to maintain the property as residential only. So think back to what we saw in that proponic schema. And as a matter of fact, let's go back and look at it again in more detail. Okay, here we are again at covenants. At real covenants and equitable servitudes. There are elements to a real covenant and to an equitable servitude. I don't see any evidence that Nancy is asking for damages, so I'm going to focus on equitable servitudes. The elements are intent, notice, and touch and concern. So you would need to analyze those elements to demonstrate that a recovery under equitable servitudes is possible. What about real covenants? Back up to that, even though I don't see facts that go to a damages remedy for Nancy. You'd want to discuss it anyway. This is a restrictive covenant, and so there were the elements. The remedy there is damages. All right, but bigger issue, I think, is the issue of implied, reciprocal, negative easements. We talked about those elements, about the need for a common grantor, a common planner scheme, other restricted lots, and at least one of the three kinds of notice: actual, constructive, and inquiry. One of the quickest ways to lose points on an essay like this under the issue of implied negative easements is to fail to understand that there are three kinds of notice and briefly analyze all three kinds and tell the reader that any one kind of notice will do. This hypothetical screams for you to analyze defenses. So look at the defenses. Changed neighborhood conditions. There, non-enforcement of the covenant makes it a changed neighborhood condition, and they gave you deep facts that went to that. 5 other businesses operating out of 5 homes in the subdivision for over 10 years, including 2 coffee shops, 2 clothing stores, and a dry cleaner. You would want to get those specific facts into your analysis in this hypothetical to show that they had not enforced the covenant, and that means that changed neighborhood conditions exist here. And that's a defense to enforcement. Alone makes it unlikely that Nancy will succeed in a claim against Linda. But wait, there's more. The second part of this is that neither Nancy nor other lot owners had complained previously. What does that go to? How about latches? Latches are unreasonable delays that cause prejudice. Look at all that Linda had done. She cut down the trees. She cut down the hedges. She greatly altered the residence to decrease the size. All of that work was visible. And now we're sitting out here at the other end of all that, and now Nancy complains. That's an unreasonable delay that's going to cause prejudice to Linda. So argue that one as a defense against enforcement of this covenant. What else? Look, to raise your score on a bar essay, if there are 4 possible defenses to enforcement, you want to raise as many of them as you can using the facts you have. Everybody will see 1. A lot of people will see 2. Fewer people will see 3 and be able to analyze them. We've gotten 2 so far. What are the other 2? Unclean hands. That's unethical conduct with respect to the transaction at hand. You can argue that. I don't see anything outright unethical here. If they'd told us that Nancy has a business on her property, then I would say that would be a stronger defense. What about the 4th one? Estoppel. That's detrimental reliance on Linda's part. I would argue that, under these facts, that she detrimentally relied on the fact that there were so many other businesses among those 15 lots. And so she relied on the fact that the covenant was no longer in force, and she relied to her detriment. I think if you can add that 3rd defense, you're stepping up into well above passing territory on this essay. So look, if you've stuck with me this long on this long debrief of this fact pattern, congratulations. But I hope one of the main takeaways you've gotten from this is that when it comes down to actual endpoint studying for the bar, memorizing the core that you need to know to write these essays, it really is a small, manageable amount of law and rules that you understand thoroughly.